Yes, Shelly ma'am, are you ready?
Yes, okay, I'm starting the session.
Let me ma'am formally introduce yourself before the start of session. So ma'am, should we start it? With your
Yeah,
kind
can
permission?
you all see me?
Let me formally start. A very good afternoon to Honorable Ms. Shelly Chaudhary, Examiner of Patents and Design, Indian Patent Office, Government of India, New Delhi. Our worthy Principal Ma'am, Dr. Atima Sharma Dwivedi, esteemed faculty members and dear students. We at Kanya Mahavidyalaya Jalandhar are honored and delighted to host Intellectual Property Awareness Program under National IP Awareness Mission in association with Ministry of Education's Innovation Cell, MIC, AICTE, TPIIT and IPO. Kanya Mahavidyalaya Jalandhar, designated as Heritage Institution by Ministry of Education, Government of India, in view of its 137 years of historic legacy and having an internationally recognized iconic stature, has been imparting transformative education through 3 centuries of its existence. It is own kind of institution with the proud privilege of having been visited by 5 presidents and 5 prime ministers of India. KMV is scaling unparalleled heights under the able guidance of our worthy Principal Ma'am, Professor Dr. Atima Sharma Dwivedi, whose vision, wisdom, and passion are apparent in every aspect of KMV to serve the society and the nation. So let me invite our wings of light, our pillar of strength, and constant source of motivation, that is our worthy Principal Ma'am, for welcome address. Ma'am.
Thank you, Dr. Neetu, for formally introducing the program. I would request the teachers and the students to keep themselves at the mute mode so that the program can be run uninterrupted. And you can supervise the students and ask them to keep their mute mode on. So, at the outset, on behalf of the fraternity of Kanya Mahavidyalaya, I welcome Dr. Shelly Chaudhary, and thank you for being with us today for this very valuable interaction with the faculty and the students. Dr. Shelly, we understand the importance of innovation and creativity, not only in today's world, but also especially so for the Indian society and the nation, because this is where we are lacking in innovation. And I'm very grateful to the Department of Science and the overall policies of our government to focus on innovation. The innovation cell of the institution is, very energetic, and we are very inspired to take the work forward and take this message to each faculty member as well as the young students to be innovative. And the IPR, the education of IPR is the most important thing, because we understand that Indian society and Indian people are very creative, very hardworking, and those who wish to be focused can bring wonders with their creativity. So, with the education, with the enlightenment and the awareness of IPR, I think more and more of people have begun to think about the IPR and work towards formalizing whatever concepts, the new ideas that they can have. The Institutional Council of our institution, as you can see, Dr. Neetu Verma is just being introducing, and she's one of the major members. And then we have Dr. Rashmi Sharma and all the other teachers who are working towards it. My congratulations. And without saying anything more, I don't want to take all this time. So better we now have Shelly Chaudhary ji with us and begin her talk. My congratulations to all of you, the faculty of Kanya Mahavidyalaya, to get connected with this IPR whole project. And thank you once again, Dr. Shelly, for being with us. And I hope you continue to mentor our students and the community of Kenya. Thank you very much.
Thank you, ma'am. Thank you, ma'am, for your so kind welcome address. In sync with the recent trends and global practices, this legendary institution has adapted itself to sustainable changes to shape up the careers of well-rounded individuals of 21st century. So intellectual property rights, IPR, is this awareness is critical for shaping an environment that is conducive to foster creativity and innovation in the country. It is essential to nurture creativity and ability to innovate at a young age. Today, on the occasion of World IP Day, during IP Literacy Week celebration under Kalam Program for Intellectual Property Literacy and Awareness Campaign, we have with us Ms. Shelly Chaudhary, who is Examiner of Patents and Design at Indian Patent Office, New Delhi. I am sure that our budding innovators, as well as my fellow colleagues, will learn a lot from today's session. Without wasting much time, now let me invite Ms. Shelly Chaudhary for her expert talk on intellectual property awareness. So, Shelly ma'am.
Thank you, Dr. Neetu and Professor Dwivedi for the warm welcome and introducing me. I'm here to make you all aware about the IP rights. And as this is the IP week, we are celebrating the IP week. And of course, our office has organized or conducting an awareness mission related to intellectual property rights. So without wasting much time, I'm directly starting my talk. So I'm sharing my screen, and I request you all to mute your mics so that this talk will be smooth. I can take this talk smoothly, and I'll be taking all the queries at the end of the session. So, can you all see the screen?
Yes, ma'am.
And I'm audible, right?
Sure.
Okay. So, this is a national intellectual property awareness mission. We all are here for getting some insight related to intellectual property rights. So, as you all know, as far you must be knowing that property relates to whenever the term property comes, we generally feel that the movable or immovable things like cars, buildings are property. But there is another kind of property as well, which is called the intellectual property. And in this, certain IPRs are there, like patents, designs, trademark rights, geographical indications, copyrights, and semiconductor integrated circuit layout designs. So, as you are seeing a laptop, this is a single. Please mute your mic.
Yes, Shadi ma'am. Do you have some, being a host, you have a setting everyone, including yours. So please make it.
I'm trying. Okay. So in a single product, as you are seeing a laptop, you can get more than one IP rights, intellectual property rights. So I've muted everyone, but don't know why this voice is coming.
There is an option that everyone can unmute.
Yeah.
So
I
make
did
it
that.
this option off.
I did that. I've muted all the participants, but Neetu ma'am, you can. You are the co-host,
Shashi, you
so you
become
can
the
also.
host. Mr. Shashi, you become the host, and I think you should mute everyone from your side.
Dr. Neetu is a co-host, so can you do this favor?
Sure, I will.
Have the access of
try.
muting all
will
the
try.
participants? Okay.
Ma'am, but it demands me the host key.
Host
So
key.
from your host side, it should be possible.
Okay, I've muted everyone because. Okay, let's see.
Ma'am, can you make Mr. Shashi as a host?
No,
So we will do the needful.
I'll be the host only. Okay, now. Okay, as you are seeing a single product laptop, then you have an Apple logo on this laptop, and similarly you have some companies logos on your mobile phone also. So for logo part, you can get the trademark rights, and for the body of the laptops, you can have the design rights, and for the technology part like LED display, you can have the patent rights, and for the user manual, like all the written instructions, you can have the copyright, and for the layout of integrated circuits, you can have the SICL design rights. So in a single product, you can avail more than one IP rights. So basically, intellectual property is a cocktail of three ingredients. That is, when you use your brain and the optimal resources around you, and you put hard labor into it or labor into it, then what comes out is the property. And as it has been produced by your brain, then it will be named as intellectual property, and you can have certain rights over this intellectual property. Now, what is the importance and significance? You can protect it. You can exclude others from using your intellectual property, and you can utilize it in a commercialized manner to you can invest it to earn money. And for the research students, if you have any sort of intellectual property rights and you use it in your CV, then it will be a matter of pride in your academics. So you can use it for your own use, or you can go for franchisee and commercializing it just to earn the money. So for as I've already told you, so for common person, uh, he or she can use it in his or her academic part, or it could be a matter of pride for for her or his academically, and he can commercialize it for companies, for businessmen. It will add to their brand value, and they can earn and invest their IPRs. So now first I'll take the patents. What is patent? Patent is a grant by sovereign or state to a person, giving exclusive right from making, using, exercising, vending, and importing an invention for a limited period of time in exchange for disclosing it in a patent specification, such that anyone having average skill in the art can reproduce the invention, and it will give a right to exclude others from using your invention, and owner has a qualified right to use the invention. It means that to get a patent rights, you need to give your invention in a specification in a way that you'll have to disclose each and every aspect of your invention in a manner that a person who is working in a similar field or in a similar subject matter of yours, means like yours, and who is having an average skill, means he should not be overqualified or underqualified. He must be having an idea about that field. So by going through or by reading your specification or drafting of your invention, he or she can make or reproduce your invention easily. So for that, you need to disclose your invention to the patent office, and for filing or getting rights in India, you'll have to apply in India. And as per the Indian patent laws, you may get the patent rights. And if you want to get patent rights in some other countries, then you'll have to apply there separately. And as per their patent laws, they might give you the patent rights. So it is a grant by sovereign or state. So uh, uh, there is no such term like global or universal IPRs. Intellectual property rights are territorial in nature. This is what I have just told you, and it this is an exclusive right, means it will be given to the inventor only to exclude others. He can exclude others from making, using, exercising, vending, and importing, means without uh, without his permission, means without inventor's permission or applicant's permission, no other person can make use of that invention. So as you are seeing, there was a scientist, D. Penning. He invented an efficient pankha pulling machine. Earlier, servants were used to pull the pankhas for kings and or queens. Then he invented a machinery of pulling the pankhas, fans. Then so for that, for royalty purpose, he filed his application to the government of India. And likewise, there are different scientists and their inventions, like for Edison invented phonograph. You all must be knowing that. These are the famous scientists. So they could have the patent rights on their inventions. So likewise, these are the famous inventions, like nano car for providing an opportunity for middle income families, hepatitis vaccines, Jaipur foot this affordable prosthetics, like means for getting a patent rights, you means there is no need to make a rocket for that, means there is no need to do a complicated invention. On very simple products you can avail the patent rights, like these all are the patented items, like the first product, you are seeing a product uh, protecting a baby's face. So this is very simple invention, and this is a patented product. And in the second one, a band with skin interface mobile, um, credit or debit card reader in mobile phone also, and then drone. Then the patent application filing process. For filing a patent application, there are certain mandatory forms, and fees are there for these forms. Means for some of the forms there are fees, and for some of the forms you need not to pay any fees. Like Form 1 is a mandatory form in which you'll have to give the details of application, like applicant name, address for service, your title of your invention. Every those aspects should be given in Form 1, and fees need to be paid. So this will be an application fees. Then in Form 2, you'll have to give details of the invention, like title, background of invention, particular of drawings, any graphs or datas if you are having. Then brief description of invention, claims should be there, abstract, summary, drawings, and fee up to 30 pages and 10 claims. There are no fees, but beyond that, means after that, if you are adding one more page, then you'll have to give the fees accordingly. And then you'll have to fill Form 3, details of foreign filing of similar invention. If you are filing your patent application, or you want patent rights in some other countries, then you'll have to give all the details by filing Form 3. And if there is any update in that particular country, then then also you'll have to give the details in Form 3, and fees is not required for that. Then Form 5, declaration of inventorship, means the applicant has to give the details of the inventor. Like if applicant or inventors are different, then applicant should give the details of the inventor also. Otherwise also, if applicant or inventor are same, then also Form 5 should be filled, stating the name of the inventor, who is the real inventor of that particular invention, and fees is not required for that. Then Form 18 is the request for examination. Like you have applied for patent application by filing Form 1, but you'll have to file Form 18, and fees will be there. Unless you file this form, we as an examiner will not examine your application. So this is for the examination purpose, and it shall be filed within 48 months from the earliest priority date or filing date. If not filed, application deemed to be withdrawn. So this is the timeline. 48 months from the earliest priority. Earliest priority means the date of first disclosure of your invention, when you have disclosed your invention at the very first time. So counting from that particular date, 48 months will be counted. Sorry. So there are different fee structures for different forms. And for the natural person means any individual, or startups or small entities, means for small companies. And for the educational institute, fees is different, means a bit lower. Then other than the natural person, means the companies, the big companies. So you are seeing the difference between the fees. And for more details of the fees for other forms as well, you can refer to the first schedule of the Patents Rules 2003. And I want to add some information here that after 21st of September 2021, there is an 80% fees reduction for the educational institute, whether it is a private educational institute or a government educational institute. 80% fees has been reduced for patent application filing or examination process for other forms as well. So now filing a patent application is much cheaper than before for educational institutes. Now this is how you can file, means if you are submitting a hard copy, so you can directly come to the patent office and file it. And if you want online filing, then you can visit this IP India website. This is the full link. So you can go and fill the means follow the steps and can file online also. This is how the e-portal looks like. You'll have to make an account and follow the instructions to submit your application. Now there is a provision of expedited examination also if you want to speed up your examination process. So who can go for that? If an applicant is a startup, small entity means small companies, and if an applicant is a female, if there is a single female applicant or joint applicant with one, means there should be one female applicant in joint applicants. So they can also go for the expedited examination. For Department of the Government and other government establishments, expedited examination means they could avail this speedy examination process. And if you are choosing India as an ISA or IPA in PCT, PCT is a Patent Cooperation Treaty. It is one of the routes of filing the patent application, and PCT is between the member countries, like it is a treaty between different countries, and India is also one of the members of that treaty. And if you want to file a single application for applying in different these member countries, so your at first stage your application will be examined, and for examining your examination, if you are choosing India as the examination authority, then you can also go for the expedited examination. And if there is an agreement between Indian Patent Office and a foreign patent office, then that foreign patent office can also go for the expedited examination. Like Indian Patent Office has an agreement with Japanese Patent Office, so Japanese people can go for the expedited examination. Now, patent application processing. So as I've already told you the PCT, so there are 3 different kinds of routes through which you can file your patent application. PCT and convention are the foreign filing routes, and ordinary when you are filing within India only. So the difference
Sorry,
is
ma'am, for
between
the
the
interruption.
timelines.
Sorry, Shelly ma'am, for the
Yeah.
interruption.
Yeah.
Actually, our students are in the waiting lobby, and I don't have a permission to join them. So can you please give the permission so that our students in the
Okay.
waiting area can join?
Okay.
Thank you.
Okay. Fine. I think everyone has joined. 2 participants.
Yes, Shelly ma'am, you can give the permission to me so that I can join without interrupting you.
Okay. I don't know how to. I've already. You are the co-host, na? So
Yes, but I am not able to
okay.
As a co-host with permission. Or you can open the waiting area so that anyone can join
Okay.
without getting the permission. Thank you, ma'am.
Okay. So the difference between these routes mainly is for the timelines. Like if you are coming through PCT, so like if you are if you are coming from USA, so if you have you are a USA applicant and you have already disclosed your invention there, so you have a priority date in USA. So counting from that, you can file your patent application in India through PCT within 31 months from the earliest date of priority. Then there is another route, convention route. I think every participant. So convention route is there, Paris Convention. So you'll get 12 months time to file the application within India. If you are coming from some other countries, some member countries who are in the Paris Convention, who are the members of the Paris Convention. And when you are coming through ordinary route, then you have the provision of filing either a provisional specification, and within 12 months of that you'll have to file the complete specification, or you can directly file the complete specification. Provisional specification means if you have means if you are that much sure, like okay, within 12 months of time I'm going to complete my invention, so you should not wait till your invention will be fully completed. You should make a draft. There means it is not necessary that it should include all the claim parts. In complete specification you will have to include the claim parts, but in provisional specification you can make a rough draft as per the law, patent rules or patent act, and then you can file it in means you can give your application to the patent office, and by this you can reserve your date of filing at the earliest. So you need not to wait till your invention will be fully completed. You can go for the provisional specification, and once it is done, then within 12 months you will have to go apply or file the complete specification with all the claim parts. And after 18 months you'll your application, your specification or your complete specification will be published in patent journal. You can for seeing this journal you can go to the IP India website. So your specification will be published under section 11A after the expiry of 18 months, and you can go for the early publication also. If you want to publish your application early, then there is a form 9, and you'll have to pay the fees for the early publication. And after this your application will be allotted to the respective examiner of that particular field, and he will make a report and put up to the controller of patents and designs, and controller will issue the first examination report. In patent office, for examination purpose, we have 2-tier examination system. That first your application will be examined by the examiner. He will see he or she will see all the formal checkings, like for forms, for fees, for timelines, and then he'll go for the technical examination, in which this is the main examination of your application as per the subject area, and the criteria of judging your application will be novelty, inventive step, and industrial applicability. So on these criteria, the technical examination will be done by the examiner. Then once he or she has made his or her report, then he will put up his report to the controller. Controller will again go through the report and will see if means report is okay or not, and if okay, and he finds that the report is okay, then he or she will issue the first your examination report, which will be called as first examination report. And now the applicant needs to reply within 6 months of issue once your this first examination report will be issued, then within 6 months of that, applicant needs to reply, and you applicant will get 3 months extension time by filing form 4, and fees will be there. So total 9 months time. Within 9 months time, an applicant can reply to the first examination report. So again, the examiner will go through the reply filed by the applicant and will see for all the objections, and then he or she will again make a report, and then report will be put up to the controller again. The controller will again see for the for any objections, and then subsequent examination report will be issued by the controller. And then comes the hearing and disposal part, that if objection is maintained, then your application may get rejected, and if your objection is complied by the applicant or objections gets removed, then your application may go for the grant part. Then comes the screening and classification. Once the application for the patent is filed by the applicant, then it goes for the screening and classification part. In screening, it will be screened for the atomic energy and defense related things. If your application is related to these areas, then it will be referred to the respective departments, like atomic energy department if your application is related to atomic energy, and DRDO if your application is related to defense purpose. And after getting clearance from these departments, then only your application will be published. And in classification, your application will be classified as per the subject areas, and after that, publication of your application will be done, and then allotment of application to the examiner of that particular subject area. Now, as I've already told you that examination will be on formal and technical aspects. First examination report will be there. In this, gist of objections are communicated to the applicant. Examination on reply of applicant. This is on the amendment part. When applicant has already replied for the first examination report, then again examiner will check for the reply, re-examine, remove the objections which met the requirement, communicate the pending objections to the applicant. This is how the examiner will make the report, subsequent examination report. Then comes the hearing part. Technical discussion on pending objection between applicant and hearing officer, and grant or refusal. Decision to grant or refuse the patent based on pending objections and submission of the applicant. Then in this technical examination will be there, that examiner will check for the novelty and inventive step with respect to the citation. Actually, in examination, we as an examiner will see all the documents, all the citations, all the publications on the worldwide databases before the date of filing of your application. So after getting the citations or publications, then the examiner will judge or check your application with respect to the citations or prior arts or publications, and then he or she will make the detailed examination report. So these are certain timelines, like for after filing provisional, then you will have to file complete specification within 12 months, request for examination 48 months, and reply to FER 6 months, Form 3 6 months. In Form 3, I have already told you, you'll have to give the details of foreign filing. So within 6 months of any foreign filing, or if there is any updates in that particular country, then within 6 months of that, you'll have to give all the details to the patent office by filing Form 3. Then Form 5, declaration of inventorship within 1 month of complete specification. Then withdrawal of application 15 months, hearing submission 15 days. There are provisions for pre-grant opposition and post-grant opposition. Like before grant of your application, any person interested can go for the opposition part. Means if he has certain objections over that particular examination report on your invention, that then any person can oppose that report in patent office. And post grant opposition is the opposition again filed by the person interested after the grant of the patent till 1 year. Means within 1 year after the grant of the patent, any person interested can go for the post grant opposition part if he or she has any objection related to your granted patent. Now comes the designs. This is another intellectual property rights. So patent is for the technology part, but the designs is for the outer configuration, shapes, lines, colors of the product. As you are seeing a car, so the design right will be given only to the shape, color, configuration of the product. And in this, only novelty will be judged solely by the eyes, by human eyes. Means how much novel this product is. So for patents, you will be seeing novelty, inventive step, industrial applicability, and but for the designs, you will be judging only the novelty aspects. And the term of design is 10 years, and it can be extendable to 15 years. And term for patents is 20 years. Means an applicant can enjoy his or her patent rights till 20 years. So for designs, the product or article as per the section 2A means any article of manufacture which can be and any substance, artificial or partly artificial and partly natural, and includes any part of article capable of being made and sold separately. So articles should be could be purely artificial, or it could be partial artificial and natural. And original means in relation to a design, means originating from the author of such design, and includes the cases which, though old in themselves, yet are new in their application. So the product, the designs should be new in their application. As you are seeing the different products with different designs, So the design right will be given only to the design part of the product, not to the technology part. So simple design of a mask you are seeing, so on that also you can avail the design rights. So this is a set. This is also a product, but can be used in a set forms. Means in set means a number of articles of same general character, ordinarily sold together or intended to be used together, all bearing the same design with or without modification, not sufficient to alter the character or substantially to affect the identity thereof. So T set you will be using it together only. So it will be not like that that for plates you will be getting a different design right, for cups you will be getting a different design rights. No, for the whole set you will get the single design right. So just like tea set, jewelry set, sofa set, which you are using together, all together. So there are 4 offices: IPO Delhi, IPO Mumbai, Chennai, and Kolkata. You can file your design applications here, but the nodal office is IPO Kolkata, where the applications related to designs will be examined. And for physical filing, you'll have to give the DD, demand draft, in favor of controller of designs payable at Kolkata. And then all the examination, registration, publication, post-registration, all the processes of examination will be done by the IPO Kolkata only. Now, like patents, for designs also, there are certain forms and fees. So for application fees, 1,000 for individual, startup, small entity, and 4,000 for the big companies, big entities. And application form 1, giving details of applicant name, address, nationality, class number or name of the articles, priority date if you are having any, if you are claiming any priority date. Uh, then 2 sets of representation. Uh, illustrating various views of articles. So you'll have to give the drawing in such a manner in 2 sets, illustrating various views of articles. Then power of attorney if required, form 21, if and then assignment documents if any, form 2, if applicant is small entity or startup. If you are claiming that you are a small entity or startup, then you'll have to produce the certificate related to these particular criterias. For patents also, you will have to prove that you are a startup or a small entity. So this is how the illustration of designs means. In this manner, you'll have to give the drawing part, and no design right will be given to any name, logo which is present on this drawing, only for the drawing part. If you are having any inner design, so this is how your drawings should be look like. Now this is the certificate of registration of your designs. If your design has been registered, then you will get this sort of certificate having the design number, applicant name, address, everything. So this is how your design application will be published in patent journal with drawings, applicant name, title. Now once you get the design right registered, so before selling your products in market, you'll have to mark those products with writing registered or REGD or RD. So this may deter potential infringer and help in legal action. So importance of filing important things for filing the design rights is reply to first examination report should be filed within 6 months from the date of filing of application, similar to the patent applications. The 6 months can be extended up to further 3 months. In patents also, you can get the 3 months time to filing the reply to the first examination report. Here also similar thing is there. So term of designs initially for 10 years from the date of filing and extendable by another 5 years. Then request for renewal to be filed within 10 years. And for patent also, you'll have to pay the renewal fees. Then request for restoration of lapsed designs to be filed within 1 year from the date of cessation. So if you're to restore the lapsed design, you'll have to you'll have to request for restoration within 1 year from the date of cessation of your design, lapsed design. Now comes the trademarks. This is another intellectual property rights. So a trademark is any word, logos, symbols, and it identifies and distinguishes the source of the goods or services of one trader from those of others. Different companies use different logos, signs to differentiate between the products of themselves and the other companies. Then its function or importance provides exclusive monopoly over a class of goods or services, allows a business entity to build public goodwill and brand reputation, identifies the source or origin of goods or services, assures customer about quality of goods or services. Like subject matters included in trademarks, as you are seeing a McDonald's symbol, M is written in a particular manner and with yellow color, and background is of red color. So by seeing this symbol or logo, you'll automatically identify that okay, it belongs to McDonald company. If you want and if a different type of M is there, then you can differentiate between these two symbols, that okay, this symbol belongs to McDonald's and that particular symbol does not belong to McDonald's. So if you want to have burger of McDonald's, then you will surely go to this particular sign. So this is how company uses the logos to make their customers or consumers of their means of their companies related to that particular logo. By seeing only their logo, you can differentiate between different companies. So this includes the service mark, like you are seeing the Naukri.com. So this is a service provider. Then trade name. Trade names like Google is a full name. You are seeing in a different manner. G is there with different color, O with red color, and the second O is of yellow color. So this is how the trade names can be registered. Then collective marks like Adidas, you are seeing the lines as well as the full spelling of Adidas. Then certification marks like Bureau of Indian Standards. So by seeing this symbol of Bureau of Indian Standards, so you can be assured of the quality of that particular product. Then tagline or slogans like Pepsi has used a tagline, Ye Dil Mange More, and it is also written in a particular manner. So so now this line has been trademarked or to the Pepsi company, and now no other company can use this trademark. And if any other company does so, then that Pepsi can sue them or can take them to the court. Then shapes, like you are seeing a tick, so everyone knows that this tick sign belongs to the Nike company, Nike shoes. Whenever you see this tick mark on any shoes, so you'll be automatically aware that okay, this shoe is of Nike. So this is how company uses these trademarks. Then sound marks. Sounds can also come under trademarks. Like you are seeing a Columbia. This is a production house. So every when you go to watch any movie in theaters, so you must have seen a particular production house has a particular or a specific sound. Every production house has different sound with their uh, company name when it comes. Or another example, when you switch on or switch off your mobile phones, then Samsung has some different sounds than that of the iPhones, or OnePlus will be having some different sound when you are switching on or off your mobiles. So those sounds can also come under trademark. So a good trademark, how should you go for the trademark for your company? So it should be distinctiveness. There should be a distinctiveness. It could be inherent or acquired from the market, not deceptively similar, honestly adopted or coined. Means it should be original. It should not be copied, not similar to already existing mark. Before adopting a new mark, it is advisable to have a search conducted and evaluated. It also avoids unnecessary litigations. This is not moving. Now, this is how you can indicate your trademarks. If your trademark is fully registered, only then you can use this R sign within the circle. And if the process or filing process or your application is in pending stage, then you'll write this TM mark. Like McDonald's is fully registered trademark, so McDonald is using R within the circle, and the coffee chain company like Starbucks, that Starbucks uses a TM mark because its application is under the process of that trademark application. Means it is not fully registered. So whenever you see a sign with TM or R within the circle, so you can easily differentiate that if there is R within the circle, means this mark is fully registered and that particular company has full right on that particular mark. And if you are seeing TM with any sign, so it means it has not been fully registered yet. So how to protect your trademark? Trademarks registration is optional. However, registration has certain advantages. So there means it is not mandatory to have a trademark registration, but after getting fully registered trademark, if anyone if anyone will use your mark, then you can take that company or a person to the court, and you'll be having a full proof, a written proof that this mark belongs to you or your company. Then registration available at the national, regional or international level. Initially registered for 10 years, can be further renewed indefinitely, 10 years each time, so on. So in every 10 years, you can go for the renewal of the trademarks. In case of non-use, non-renewal or no policing, trademark rights are lost. If you are not using your trademarks, then it can be lost. The existing trademarks registration is governed by the Trademarks Act 1999 and the Trademarks Rules 2017. For more detail, you can visit the ipindia.government.in website. So all the IPRs are governed by their respective acts and rules. Now comes the copyrights. So copyright is for the artistic work. Whenever you have an idea in your mind and you framed it in a written manner or publish it somewhere on some social media platform. So after that, after publishing it or when it comes in the publishing material, then you will automatically be having a copyright over that particular work of yours. So, and the works for some particular works, you can go for the copyrights as per section 2Y, and the section 13 of the copyright provides for the works in which copyright subsists. So, and your work should be original, should be creative. So these are the criteria for the work to be copyrighted. These are the acts that governs the copyrights. So these are the subject matter of copyrights. These all subject matters come under the Copyright Act. Literary works as per section 2O means if you are a research scholar or doing research, so you can publish your papers or can write the books, and then you will be having a copyright over your own work on your own published papers or books. Then artistic works as per section 2C is like painting. Then dramatic work on dramas, also on performances of dramas, you can also have the copyrights. And for musical works like musical notes, these can also come under the Copyright Act as per section 2P. Then sound recording works, cinematographic films. Now, who all are the authors of the work? For literary or dramatic work, the original author of that work will be the first owner for the copyright. Then for music work, music composer, artistic work other than a photograph, artist will be the first owner of the copyright. Then when there is a photograph, then who will be the author? Person who is taking the photograph, not that person whose photograph is that particular photo, but the person who is taking that photo will be the first owner. You must have seen right now in Instagram, whenever someone uploads a picture, then he or she will give hashtag pic credit goes to that particular, means a particular person. So it means before uploading or on uploading of that particular photo, that person is giving credit to the photographer, so that if that means just to avoid the copyright things. But that is also not the legal thing that okay, after giving the pic credits, now I'll be safe. But that unless you have such some agreement or the permission from the original photographer, you should not means upload any picture. So a cinematograph, film or sound recording, for that producer will be the first owner. Literary, dramatic, musical or artistic work which is computer generated, the person who causes the work to be created. Now, rights of author of copyrighted work. Copyright has two rights, economic rights and moral rights. So economic rights as per section 14 are the transferable rights, may be assigned to other owners for a sum of money or royalties depending on the proposed usage of the work. So he can, the original author can have an agreement with other person or companies for monetary gains, that okay, you can sell my product or the work further, and you'll have to pay something to me. But and there is another rights like moral rights as per section 57. So even after giving the economic rights to someone in a written agreement also, then also you will be having certain rights with you, and this is called the non-transferable rights. They remain with the original author. So first comes the scope of economic rights. Right to for the right to reproduce the work of original author, for preventing others of making copies of your work, right to reproduce work in material form, distribution rights, right to create derivative works in cinema, sound recordings, right of communication to public, relaying of work by distinct or interactive communication means, right of public performance, right to perform the work in public. So these all means these works are mainly related to the creation or artistic or creativity, and mostly used in film industries like music composers, music and all that. And scope of moral rights, there are two conditions like right against distortions, integrity, and right of recognition, authorship or paternity. In first one, the right to object to the work being distorted or used in contexts that are prejudicial to the honor and reputation of the author. The author can oppose the distortion of the work in such a way that its cultural or artistic integrity is adversely affected. So, if someone is selling anyone's work, having the economic rights, but distorting his means original author's image, then original author can means he has the right against that distortion. He can take that person to the court even after giving the economic rights if his or her image is being distorted by that particular assignee. Then right of recognition means the right to claim to the author of the work and to have the authorship recognized. The right to have the author's name mentioned, for instance, when the work is reproduced. When someone is reproducing the original author's work, then he or she should mention the name of the original author on that particular work before selling further it in the market. Now, term of protection as per section 22. So, published literary or dramatic or artistic and musical work, the term of protection of copyright will be lifetime of the author plus 60 years after his or her death. The rights will be remain with that original author and after his death also. So his or her family can avail the rights of that particular work. So cinematographic film and sound recording, 60 years from the date of publication of that particular work. Broadcast reproduction rights, 25 years from the year following the year of broadcast. Performance right, 50 years from the year following the year in which performance is made, like dramas, stage performances. So, application procedure is there. You'll have to fill the form 14. Every such application can be filed in the Copyright Office by person or by post or by e-filing facility, means online. Payment can be made in the form of payment gateway or demand draft or IPO, means directly to the patent office. Now, this is the application fees for different fees for different works, like literary, dramatic, artistic, musical, 500 fees, 500 rupees. Artistic, to be used or capable of being used on goods and services, 2000. Sound recording, 2000. Cinematographic films, 5000. So these are different fees for different works. So this is the examination process. So once application is received at Copyright Office, it will go for the formal checking, and waiting period will be there for the scrutiny. If there is no discrepancy, can go for the approval of the application, and if there is a discrepancy, then that objection will be conveyed to the applicant, and then he'll has to reply within the time limits. Then his or her application will go to the hearing part before the registrar. Then accordingly he can make the decision for approval or rejection of the application. Now comes the SICLD, means Semiconductor Integrated Circuit Layout Designs. This is also another intellectual property rights. So SICLD means a product having transistors and other circuitry elements inseparably formed on or inside a semiconductor or insulating material designed to perform an electronic circuitry function. So all that electronic chips comes under this. Layout designs means a layout of transistors and other circuitry elements, and includes lead wires connecting such elements and expressed in a manner in SICS, means semiconductor integrated circuits, or the how they are arranged in that particular circuits, all those wires and elements. So for designs of that particular wires and elements can be can come under the SICLD rights. Semiconductor Integrated Circuit Layout Designs Registry, Delhi is the main office where the applications on layout designs of integrated circuits are filed for registration of created IPR. SICLD is an important IPR for protection of products with fast changing technologies such as electronic gadgets, computers, etc. We all know that these have small chips, so this is related to that particular work. The registration of a layout design is for a period of 10 years from the date of application, filing, or first commercial exploitation, whichever is earlier. So you are seeing on left hand side, on right hand side, sorry, the design part of this integrated circuit. So this is how you'll have to file your application of such circuit diagrams. Then forms will be there like any other IPR, and fees will be there, different forms will be there, and the process will be similar to other IPR examination process, that application comes, will be seeing for the any objections, any formality checking, then technical checking, and registrar can accept that or reject that as per the condition required. Then SIC, basis of advanced electrical, electronics and IT technologies. So this is mainly for those people. Now, the last GI IPR is the geographical indication, Atulya Bharat ki Amulya Nidhi, invaluable treasures of incredible India. So, geographical indication is an indication that identifies a product that have a specific geographical origin and possess qualities or a reputation that are due to that origin. So geographical, you must have heard about GI tags. So this is geographical indication tagging. So it is given to the product of a particular place Why? Because it must be having some special qualities in that. Like first GI tag has been given to the Darjeeling tea. So that tea must be having some kind of special aroma or taste, and the all the climatic conditions can be different from other climatic conditions for that particular product. Like soil can be different, or the climatic conditions could be different, and then this tea will be given the GI tag, so that the farmers related to that particular tea, means the farmers who are growing those teas, will be benefited. So likewise, different products from different places of India are given GI tags. For example, Makrana marble of Taj Mahal is originated from Rajasthan. So Makrana marble of Rajasthan is having a GI tag. So likewise, Nagpur orange, the specialty, the special fruit of Nagpur, is having a GI tag. Likewise, Nilgiri tea. Food products can also come under GI tag, like Ratlami Sev of Madhya Pradesh, Kanchipuram silk, Tamil Nadu, Katputlis of Rajasthan, Bagh print of Madhya Pradesh, Bengal Patra Chitra, Worli painting, Kashmir saffron, Shahi Lychee of Bihar. So now IP is everywhere, and validity is patents is for 20 years term, means the term for the patent is 20 years, and there is nothing called global or international patent. Designs are for 10 years plus 5 years. Trademarks indefinitely subject to renewal, initially for 10 years. Geographical indication indefinitely subject to renewal, initially for 10 years. Copyright published literary or dramatic or artistic and musical work, lifetime of the author plus 60 years. These are the terms related to different intellectual property rights. And who can apply? Person interested, any individual or legal representative person, includes firm, partnership, small entity, and a body corporate, can apply for IPRs, different IPRs, except geographical indications, because for geographical indications, the governing body or committee or board of that particular area will file the application for geographical indication tagging. And all IP rights are territorial in nature, means if you want to file in some other country, then you'll have to apply there separately. And if you want to file in India, then as per Indian patent laws, you may get the patent rights. So points to remember: first protect, then publish. As researchers, they go for publishing their papers. So this should be avoided. You should reserve your priority date first. You should not disclose your invention first in the published papers. You'll have to disclose it first. You should disclose it first to the patent office, and then go for the publishing of your any research papers. Rights are territorial, that is limited to boundary of countries. Registration is required in each country. Registration is done by sovereign authority, that is in India, Government of India. Sovereign authority means the British, the British government, like Queen and that sort of. Rights for limited period of time. So as I've already told you, the different terms for different IPRs. No automatic relief, need to file in infringement suit. If someone is using your rights, then you should go for the infringement in court. Renewal fees to be paid for some IPRs, means you for availing the IPRs for many years, then you'll have to pay the renewal fees, except copyrights and trademarks. Appointment of patent agent is not compulsory. Applicant can sign the documents and file himself. So you can yourself file or sign your applications. Now, career opportunities. For if you want to go in government sector, then government jobs are there. You could be an examiner of patents and designs, examiner of trademarks and GIs, examiner of copyrights. And for the private sector, you can be a patent agent, trademark agent, GRF or SRF in patent facilitation centers, patent litigation and other opportunities in private sector. So these are the career opportunities. And we have our patent office has a training center. This is also a government training center, Rajiv Gandhi National Institute of Intellectual Property Management, RGNIIPM. It's in Nagpur. If you want further training on some particular subject areas of how to file, how to draft claims, how to write the specification, or any other on sections, acts, rules of patents, so you can see the website or mail this institute. And trainings means you can avail the different trainings at very minimal cost. So there is a small quiz. Whosoever wants to answer can unmute his or her mic and answer this. This is just to know how much you have grasped so far. So find the famous trademarks. You are seeing this picture, some alphabets. Can you answer the famous trademarks?
Ma'am, Amul.
Yes. Anyone else?
Ma'am, Pepsi.
Yes. Trademarks means company's names, logo.
Ma'am,
So,
Tata.
yes, Tata. Are you seeing any company name? Tata. Any other?
Horlicks.
Yes.
Dettol.
Yes. So I'm revealing the answer. So means you got what is the trademark, right? So Pepsi, Amul, Tata, Dettol, Cadbury, Babool, Bata, Horlicks. So find the IP. For first picture, what IP right will you get?
Copyright.
Yes,
Copyright.
because this is a painting, so an artistic work. So for this, you can have the copyrights. And for second picture,
Design copyright.
yes. Then for third,
Trademark.
trademark. And for the design of the laptop and mobile, you can get the design rights.
Design.
And for the technology, like means the display part, you can avail the patent rights. And the fourth photo, this fourth picture,
Trademark. Trademark.
for Bisleri, trademark. And the fifth one,
Trademark and copyright of design for the shape. Design.
no, for design of the bottle, you'll
For
be
design
getting
of
the
the bottle.
design rights. And for the Coca-Cola, you'll get the trademark.
Trademark.
Which type of IP protects the painting painted by artist?
Copyright.
Yes. What protects the IP created by fashion designers?
Copyright. Design.
Yes, copyrights. But for some design rights also. What protects the advanced disc brake for bike developed by the inventors?
Patent.
Yes. For technology part means advanced disc brake has some advanced technology. So for that patents. Which of these is a geographical indication?
Nagpur orange.
Yes. And for BMW?
Ma'am, patent.
For BMW. Trademark. This is a company name, na? What does a trademark protect?
Logos, names, and brands.
Yes. How long can a patent last?
20 years.
20 years. If you write an original story, what type of IP gives you the right to decide who can make and sell copies of your work?
Copyright.
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 Imagine a cricketer sets up his own company to sell his own range of clothes. What type of intellectual property can he use to show that the clothes are made by his company?
Copyright.
He's making
Designing.
his own company, so how can he differentiate? Yes, trademarks. You must have seen Nike sign on Nike t-shirts or UCB sign on UCB t-shirts or shirts. So this is how company use their trade names. So if a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention?
Patent.
Yes, whenever technology comes, go for patent rights. Thank you. So this is all from my side. Hello.
Thank you
Neeta
so
ma'am?
much. Yes, thank you so much, Shanti ma'am, for your so interesting and valuable talk. Clearly, we have enjoyed a lot. I am sure our budding innovators as well as my fellow colleagues have learned a lot during this session. So, any questions from anyone? Can I
Good
ask a
afternoon.
question?
Yes, yes, ma'am. You can.
Ma'am, suppose we have some idea in our mind, and
Okay.
we suppose that it's a novel one. But how can we go for the novelty of, go for the checking of that novelty of idea?
Yes, so for that you can go to the to certain platforms online only. So you can go for different documents. Like if whenever you are doing any invention or research, you always go for the published papers. That okay, these are certain papers, and from one papers I'm taking this much part, and from second I'm taking that much part. So this is how you can go on different platforms for searching your invention before make it in a practice. Like Google Patents is a platform on which you can search your when you write or add some words to it related to your invention. Say for example, you are working on any compound or chemical compound, then you can write that particular compound by going to Google Patents, and then all related articles will come there, and then you can go through that, and you should see all the documents before your priority date. Means unless you haven't filed for the application patent application, so you can go for all the documents. But if you have filed, or if you have already filed your application, then you should always go before your priority date. But in your case, you will be searching all the documents on Google also. You can go for the published papers. WIPO, there is a World Intellectual Property Organization. There also you can search for the subject matter related to your invention. So you will be getting all the patent uh, literature over there. So you can go through that, and there are certain paid platforms also which the patent office has an agreement with. So that part we can avail, means that platform we can avail that. So we search on wide databases to cite the documents for your application. So likewise, you can also go on Google's other publishing house for non-patent literature, and for patent you can go for the Google patents also, Google Scholars for non-patent literature, World Intellectual Property Organization. There also you can go other USPTO, USA Patent Office. For Europe, eSpaceNet is there. Europe Patent Office means all these different countries have different document databases also, where you can go search your topics. Then all the patent literature will automatically come, and you can go through that how, up to what extent your invention is there.
Okay, thank you, ma'am. Can the paid platform, are these platforms are safe to disclose our idea? If we have any doubt about our
No,
novelty.
you are just searching. You are just putting certain terms only. Like you are working on some plant. So, whatever your invention is, you are just putting certain terms in on that searching platform, and you are not revealing your invention fully. You are just like on Google, you put some words to
Right.
get some documents. So likewise, there also you are putting certain words related to your invention, and then whatever literature or document comes, then you can go through that and can see up to how much extent your these the subject or the information has been there or has been published so far.
Okay, thank you, ma'am.
And you
Anyone
can
else?
also see the lacuna of in that particular area of your invention by going through all those documents. While drafting the patent specification, you will have to give the background also, in which you will have to give the lacuna, means whatever the up till now, what are the lacking features in that particular area. So you will be knowing up to how much extent this particular area has been disclosed, and now I have a solution for that. So then also you can go and see further that how much novel is your invention and how much non-obvious your invention to the person skilled in the art. So by this you can design your invention.
Thank you so much, ma'am.
Yes, Dr. Harpreet.
Yes, ma'am. Good afternoon, ma'am.
Graph.
Ma'am, first of all, I wanted to say thank you for this really informative session. The quiz was one of the most interesting things I've actually done in the past few days. I
You
am
are
a
a
student of
student?
plus one. Yes,
Yeah,
ma'am.
okay. This quiz
I'm a
is
student
for
of
students only. Means
Anji, ma'am.
only for students.
Ma'am, I'm a student of plus one and I'm a law aspirant. So I really liked your session. And my question was, ma'am, like there are some books and some publications which are anonymous. Like we
Okay.
don't have like the author's name, or we cannot reach out to the author to know, right? And if we
Mhm.
publish something related to that, then can someone else who may or may not be the publisher sue us for plagiarism?
See, in when you go for publishing your papers in some with some publishing house, mostly they have these conditions that they give two conditions, that whether you are surrendering your copyrights or whether you want to avail your copyrights. So in that particular uh, publishing house, all the details will be there of that particular author. And if you are seeing a published article, irrespective of its author name, but it has already been disclosed in public forum, then that particular author has copyright over his or her article. So without also knowing his name or her name, if you are seeing any article published or on any social media platform, so means if you are using that, so it means you are what you are doing against his or her copyrights, no matter this is an anonymous or whatever it is. If he will see that okay, that particular uh, uh, document or patent relates to me, so if he has certain proof, if he can prove that it belongs to him or her, then he may go for the copyright issue. And if no one is there, so it depends totally on you that okay, this is anonymous, okay, I can go for it or not. So it will depend upon the conditions fulfilled by that particular publishing house with that particular author.
Thank you, ma'am.
I hope, am I clear?
Yes, ma'am.
Okay. Yes. 251736092267. So name is not there. Number is
Ma'am,
only there.
is it, ma'am, my name is Aarti.
Okay.
So, ma'am, my question is an extension to what you were already answering. You were answering from user's point of view. My question is from the author's point of view. Suppose I'm writing some story or writing a poem, or I'm an artist. I'm doing some work and I'm publishing it on my personal social media handle, say on Insta or Facebook page. So once as I publish, it automatically falls into copyright. Like,
Yes.
can I claim it?
Yes. I have already told you that trademarks and copyrights are optional. So by putting it on any social media, you will be having copyright over that automatically. But it's better to have the certificate, the registered certificate of copyright, so that anyone who is infringing your rights, so you can go for you can sue them in court also, and you'll be having full proof means the proof with you that okay, it belongs to you, and on that particular date I have put it on social media, so it has already been published, whatever it
Okay,
is. So
okay.
it's better to go for copyright applications, and the fees is very minimal. So I don't think it will be a problem for
So
final.
actually, I raised the question as you have protect before you publish. So that's what you are saying right now.
Yeah.
Thank you.
Thank you. Yes, Dr. Gurpreet Kaur.
Yes, good afternoon, ma'am.
Good afternoon. This will be the
So I
last
just
question. I think time is
okay, ma'am. Okay. So I just want to ask, can the life of a patent be extended?
no. 20 years means 20 years. You'll have to pay the renewal fees. After 20 years, it will be of public use. So term is 20 years.
So
Hmm.
there
You
is a
cannot
term called evergreening of the patent.
So to avoid ever, what companies does that, okay, I have patent on that particular on a particular invention. So now what company does, because that company knows that okay, I'll be availing the patent rights only till 20 years. So what they do, that they just do some technical differences in that particular invention, keeping the basic invention same. They again go for the for another patent filing, keeping the basic invention same. So like this, this is called the evergreening of the patents. So to avoid this, um, patent has been restricted to 20 years only, but company does this sort of work. So this is called evergreening, but the patent term is 20 years only.
So with this, they can extend it to period of time is doubled.
No. They'll have to file the, a new application.
Okay. Okay, ma'am.
See, they are again filing a new application with similar kind of invention. So this is so on that. If an examiner examine that or found some a different technical, or if it fulfills the criteria of novelty inventive step, then that company will again get the patent rights in a bit different, only a bit different invention, again to 20 years. So this is called evergreening, but he has to file the patent application, a new patent application, and for one invention the patent term is 20 years only.
Okay, ma'am. Thank you, ma'am.
Okay, I think that's all from my side.
Yes, ma'am. Really, the talk was very interesting. Now I invite our Vice Principal Ma'am and Dean Sciences, Mrs. Parminder Kaur, Ma'am, to have a formal vote of thanks.
On
Parminder
behalf
Ma'am.
of Heritage College, Kanya Mahavidyalaya, I deem it my proud privilege to deliver vote of thanks to our resource person, Ma'am Shaili Chaudhary, who is examiner of patents and design IPO New Delhi. We are highly obliged to you, ma'am, for sparing your precious time to deliver such a fruitful, informative, and detailed talk on patents, design, and copyrights. We look forward to such meaningful interactions in future too. I'm also
Of
thankful
course.
to our principal, ma'am, for providing us with such exposure. My thanks also go to our institutional IPR cell for organizing this event. Thank you, everyone. Thank you.
Thank you, ma'am. Thank you. Okay. Thank you, all the participants. Thank you for listening. I hope you all got some insight of IPRs and different types of IPRs. Okay, thank you.
Okay, thanks
Thank
to
you,
all.
ma'am.